So we actually are here today with the help of one of the physicians that referred a family to the Children's Law Center, and we were able to provide special education advocacy for that child. So to just kind of give you an example, this family was referred to us because the child had been diagnosed with narcolepsy and cataplexy and was not receiving any services or accommodations at school. She was actually in pre-K at this time, and as you can imagine, struggling significantly. And with the assistance of Dr. Judith Owens, who was speaking here earlier today, we were actually able to get a great IEP set up and services in place to help this little girl. So to just start from the very beginning, students with disabilities have a number of affirmative rights and then also rights to not actually be discriminated against. So the affirmative rights generally come through the Individuals with Disabilities Education Improvement Act. That's the title when it was reauthorized. And there are certain criteria that you must meet in order to qualify for these protections and services. Students with disabilities who might qualify under the IDEA or don't qualify under the IDEA but would still qualify as having a disability also have the right not to be discriminated against. And so if there are certain services or accommodations that would be lesser than what you might receive through special education, you're entitled to receive those in order to basically provide equal access. And that's through Section 504 of the Rehabilitation Act of 1973. So under the IDEA, students with qualifying disabilities have to have an educational impact, meaning that the disability negatively affects their educational performance. And the purpose of the IDEA is actually to ensure that all children with disabilities have available to them a free and appropriate public education, which is kind of one of the key terms. And it's designed to meet their unique needs and to prepare them for further education, employment, or an independent living based on their needs. I've put the legal authorities here for those of you that want to site check anything. It's Title 20 of the US Code, and then the implementing regulations through the US Department of Education are in the CFR. Each state, and then even within that, a school district is also going to have local regulations that have to, they can't contradict what the federal law or the state law says, but they're actually going to be more of like what's going to happen on a day-to-day basis within the school district. School systems under the IDEA are kind of broken up into the state education agency, and then within that state education agency, various local education agencies. Where I work in DC, it's kind of complicated and simple, where it's all one, because we are not even really a state, but there's only one. But most states are, the state education agency would be Georgia, and then within that, Fulton County's public schools, Cobb County public schools would all be their own LEAs. It can be a bit different in more rural areas where multiple cities might all fall within one LEA because of the size of the school districts. And so the state education agency, wherever that might be, is generally going to be the top that oversees all the LEAs and makes sure that they're doing what they're supposed to be doing. The LEA, so the county, city, or town, is going to be responsible for the day-to-day delivery of services. As I said, this is a federal statute, and it's designed to ensure that all children receive a FAPE, and this is also in the least restrictive environment possible, which is another legal concept that's really core to special education law. It actually serves children 0 up to 22, and it's broken up between parts or subsections. Part C is what serves children in the early intervention services. That's 0 up to 2 years and 9 months, really. And then Part B is children 3 through 21. Some SEAs, DC is one of them, have elected to allow children to continue, or students, I guess at that point, to continue receiving the services through their 22nd birthday. So if you turn 22 in April, you could continue until the end of that semester. So what is special education? The legal definition here in orange is specially designed instruction provided at no cost to the parent that meets the unique needs of a child with a disability. And that's kind of obviously a broad term. It can encompass a variety of things: travel training, if that's necessary for a student, vocational training, what people think of a lot of times, just the specialized academic instruction that a special education teacher would provide, related services such as speech, occupational therapy, And then just even not services, but accommodations. So if a child needs to be able to take naps during the day, or have breaks for movement, if they are in a wheelchair and actually need access to an elevator so that they could get throughout the school, that could all fall within the IEP itself. And we'll talk about how the accommodations and modifications might be a little bit different under a 504 plan. So as I said before, the key terms: FAPE, free appropriate public education; child find; individualized education program; and least restrictive environment. The key term of FAPE, that's kind of the basis of what all children receiving special education services should be getting. And the idea is that this public school system is required to provide this to them. Parents are not expected to go out and get it themselves. And that actually includes that parents are not supposed to know what services their children need. The educational system is kind of the expert here, so they're charged with figuring out what the child needs, ensuring that they have access to the general education curriculum as possible, that they're making measurable progress, and that the school system is really carrying the burden of making sure it's appropriate. So one of the primary responsibilities of the LEA is to actually figure out which children are going to need assistance. And so they are required to identify, locate, and evaluate children that are in need of special education services. So to do this, they have to create a comprehensive program, or a child find program essentially, to figure out who those children might be and then be able to serve them. The law is pretty open-ended here, but these are the things that it can include: a process for referrals, so actually having maybe a database where physicians or teachers can make referrals, the community outreach to referral resources. For younger kids, this generally comes through like physicians again, or child care facilities. Procedures for the referrals, as well as the timelines for the evaluations. And the program names can vary by state. For example, again, in DC, it's called Early Stages is the 3 to 5 year old evaluation center. In Maryland, I think it's actually just called Child Find. So you need to check with your state for what it's called, but the concept is the same. And this actually applies regardless of the severity of the child. So students who are still progressing and advancing from grade to grade they still need to be identified and evaluated to see if there is some impact on their academic progress. So these are what you legally would say a private right of action. So it comes down to the individual whose rights are not being protected. So it's primarily enforced through parents or caregivers essentially going to the school or to the early stages in DC, for example, and requesting the referrals. This obligation extends to any child who's going to be eligible for services. The child find does apply to 0, so very, very young children that are born with disabilities essentially, or that happen early on in their life. And that's 0 through 2, and that's going to be through the state education agency. And then special education services are actually going to be provided for children 3 to 22 by the LEA, or that local education agency again. And as I said, it is a large burden that school districts have to comply with. They have to identify children that are not attending school, those that are homeless, those that are in foster care that are wards of the state, and those attending private schools. And so each state can have, or each LEA may have different manners of doing this, but these are the populations that they do have responsibility for identifying. The IDEIA only applies to public schools, so a private school is not going to be required to provide special education services, but they can refer the family, and that's generally how public schools try to meet the criteria that they evaluate children in private schools. So to give you some background on early intervention services, this is again for the littlest ones, and it focuses on developmental services that are provided to the families here. So this is actually much more family focused, and the family becomes all families become part of the team in special education services, but the plans that are drawn up are actually focused on meeting the needs of the family to help the child develop as well for early intervention services. So eligibility depends on, again, age. We said you have to be under 3. And then you have to be experiencing a developmental delay in 1 or more areas of development. And these are the areas that would qualify. Or you could have a diagnosed physical or mental condition with a high probability resulting in developmental delay. This applies to a lot of genetic disorders. And finally, certain states have elected to create the category of at-risk infant and toddlers, where they might not have a diagnosis right now, or they might not have enough of a delay as measured by the standardized tests, but the state thinks that they're at risk for it. These are some examples of some of the criteria, some of the conditions that would automatically qualify. If a young child was diagnosed as one of these, they should generally automatically qualify for services. So as I said, there can be the at-risk criteria, and these are some areas that states can use to make services available, with the idea that these populations or having these symptoms or diagnoses are put you at risk for having delays later on. But it's not required by the law in the same way that the other categories are, so not as many states do this. So for Part C, each state actually has the first obligation of creating a definition of what developmental delay means. And so there's a little bit of leeway here where certain states might provide more services than other states. Again, for example, in DC, they just recently created a more expansive category. You previously had to have a 50% developmental delay in at least one category. Now it's opened up to children that only have a 25% delay in 2 categories. So that can be a way to get more children services. In addition to the obligation of creating the developmental delay, they have to create the same child find system. And hospitals and physicians are actually among the primary referral resources. So frequently, doctors, nurses, primary care centers, clinics are going to be the ones making a referral. And then ultimately, obviously the children need to get the services, so they have to develop the system of actually providing the services to the infants or toddlers. And that can include a dedicated service coordinator that kind of runs the whole team meetings, ensures that the people that are there are necessary, ensures that the evaluations that need to be conducted happen. And then one point, Medicaid and insurance can be utilized to pay for these services. Many states have a sliding scale. Some states actually provide all the services for free. It just depends on the state. Then what actually happens out of this process for early intervention services? Well, essentially, the IFSP, or Individualized Family Service Plan, is created, and this serves as the document that specifies what the child should actually be receiving. So it's going to include the statement of the child's present functioning based on the evaluations that were done, the family's resources and concerns, the measurable results and outcomes that they want the child to achieve. So if it's a child that has severe gross motor delays and they want to work on the child just being able to roll over or being able to crawl, those could be listed as the outcomes. It's going to list the intervention services that they're actually going to receive, so physical therapy, speech therapy, where they're going to happen. The law actually requires that to the maximum extent possible, they happen in natural environments. So for little ones, either at home or daycare centers, wherever the child normally is going to be. In general, it should be very rare that a child has to go to a clinic or a doctor's office or a hospital to receive the services, unless there's a good reason that there's a specialty piece of equipment that they need access to a specialty OT room, and so they have to have that sensory opportunity in the occupational therapy gym, let's say. Also, how long they're going to receive the services, who's responsible for providing these services, who's going to be the speech-language pathologist or the physical therapist. And most importantly, perhaps, what's going to happen when this child turns 3? How are we going to get them special education services if they're eligible, or if they're not going to be found eligible, what happens at that point? For those children who are going to be age 3, and they've either been receiving the the early intervention services previously, or they were just identified at age 3, they would be eligible for the IEP at that point for special education services. So much like the IFSP, which was early intervention, the IEP is kind of the core document that is used to figure out what the child needs, what progress they're going to make, and who's going to be responsible for that. And I always tell my clients, it's essentially a contract between the parents and the school. So if it says they're getting 1 hour of speech per week and they're not getting 1 hour of speech per week, then they're basically breaching the contract, because that's what they're supposed to be providing. It has a written statement for each child with the disability, and it's going to be developed, reviewed, and revised in accordance with the IDEIA. And that just means that there's a lot of different procedural requirements, how often it happens, who has to be there. They have to follow the procedures in this law whenever they're revising the IEP. So again, a core concept of LRE, least restrictive environment. This is a really important concept within special education law. And essentially, children with disabilities are supposed to be educated to the most extent possible in a regular education environment and have access to their non-disabled peers. So in a lot of cases, this means that children should attend their neighborhood schools unless the neighborhood school does not have the kind of program that can meet the needs of the child. But again, this is supposed to be child-based, not the needs of the school system. So if it's possible to meet the needs of the child within that neighborhood school with some modifications, that's what the school system is supposed to do. In terms of, I know there's always kind of new movements and reorganization of schools practically every year, it seems. And so I'm not sure exactly what the school system was thinking or what was working within that school district, but unfortunately, a lot of times students with disabilities do get the brunt of the reorganization or restructuring, and I know it's common that classrooms get passed between schools and students get pushed into different schools based on their disability. I mean, to the extent that they are making the free appropriate public education available to them, that's kind of the level of protection. But if they are being segregated just on the basis of their disability, then that could be a question as to whether or not they are following the IDEA. So here we're just outlining the steps to actually get special education. And it's going to be kind of similar to what we were talking about with the early intervention services, but it is different because these are for school-age children. So it starts with the referral. In order for the child to be evaluated, it has to be referred to the school system. So a parent can make the referral, an employee of the school system, so the teacher, the psychologist, for example. The child himself, if someone is 18 years old and has not yet graduated, they can actually refer themselves, or an employee of another state agency. So that frequently looks like a social worker for the child welfare system. Sometimes if the child's receiving, let's say, mental health services through the Department of Mental Health in that jurisdiction and they wanted to make a referral, they could do so. To make the referral, it's literally just a referral that there's a concern. In terms of eligibility, states have different definitions as to whether, for example, if you're saying for a child that has emotional disturbance, some states will say there have to be evidence-based. So getting back to how to make a referral, the first thing is that it needs to be made in writing. Part of that is for their documentation and also for your documentation. You want to have a date of when it's made. So it should generally go to the school system if it's depending on how your school system's organized, if there's a certain person or the principal of the school. We always say include the date of the referral, a simple statement of the educational concerns. So, you're concerned that your child is not reading at all and he's in 3rd grade. Or vice versa, concerned about math, he's reading wonderfully, but he really doesn't understand addition at all. A statement requesting the evaluations, and then a signature and contact information. Once this is made, the school, according to the IDEA, is supposed to hold a multidisciplinary team meeting, or an MDT team, to figure out what referrals or what evaluations need to be made based on the referrals. So at that time, the school should review the current information they have. That can be report cards, interventions that teachers have tried, if they've gone through the student support team process, what happened with those interventions. And then if they need further evaluations, develop a student evaluation plan to outline what's going to take place. They have to explain to the parents what evaluations are going to be conducted and obtain informed consent from the parents signing off on the right for the school to do the evaluations. The MDT team includes these people at the very least. It has to include the parents, a regular education teacher of the child if one currently exists, a special education teacher, individuals qualified to conduct or interpret evaluations. That generally means a psychologist if it's a psychological evaluation, a speech-language pathologist if it's a speech evaluation. Any other people that the school or parent thinks has knowledge or special expertise. So this could include the child's doctor. This could include the child's babysitter if they've been home and receiving services and the parent feels that the babysitter has a lot of helpful information. The child is welcome to be a member if it's appropriate. And then lastly, the school district has to provide a representative that is going to be knowledgeable about the general education curriculum that the school provides, what services are available throughout that school district, where those might be located, and also they have to have training in special education services. So they should have some background either as a special education teacher, special education coordinator, something like that. So once this meeting takes place, the LEA, or the school district, is then going to be responsible for completing comprehensive and individualized evaluations. They have to evaluate all areas of suspected disability. So this could include psychological evaluation to address cognitive issues, social emotional, there can be psychiatric evaluations if that's necessary, speech, occupational therapy, anything that is a suspected area of disability. And in general, the IDEIA says that the evaluation should be completed in 60 days. States actually provide their own timelines. DC weirdly has interpreted the 60 days unless the state determines otherwise to be okay to have 120 days. So we've somehow doubled it, which is an interesting interpretation of the law. Some common types of evaluations you'll see. These are probably the most frequent ones that you'll see. Probably the psychoeducational, speech, occupational therapy, physical therapy are the most frequent that will happen, but there may be a need for a functional behavior assessment if behavior is an issue, and that's absolutely something the school's required and qualified to provide. Once all of these evaluations are completed, everybody comes back for another meeting, and the MDT team meets again. The person that completed the evaluation, or at least somebody with comparable qualifications, so another speech-language pathologist needs to be there to review it. Then they have to decide whether the child has a disability defined within the IDEIA, and if that disability is impacting the child's educational progress, essentially. So it's going to be a little bit harder to get IDEIA services than it is to just receive the services under 504, which we'll talk about in a few minutes. So when making this decision, they have to review the evaluations that they've conducted, but they also should look at any existing evaluations that the parent might have. So if the parent has gotten a developmental evaluation through their insurance company, or a psychiatric evaluation from the child's psychiatrist, they have to bring that into the school, and the school has to review it as well and consider it. These are the different qualifying disabilities under the IDEIA. So you'll see that some of them, deafness, or let's say hearing impairment, or speech and language impairment, seem pretty obvious what they are. Others, other health impairment, for example, this includes many medical conditions. This is where narcolepsy or attention deficit hyperactivity disorder might fall. This might also include other things like sickle cell anemia. And you'll see, for example, traumatic brain injury. It's kind of what it sounds like, but it could be a variety of factors. Certain kids that have had maybe seizure disorders that have impacted their brain functioning could qualify as a traumatic brain injury. So you have to have one of these disabilities. They're all defined within the IDEIA. If you had something that did not fit within these, then technically you would not be eligible. But in general, because there are some kind of catch-all categories, as long as there's going to be an impact on academic progress and you meet one of these, you should qualify. So getting back to someone's question over here about if you disagreed with the evaluation. So parents have a right to request what's called an independent educational evaluation if they disagree with the evaluation conducted by the LEA for any reason. And technically, the parent doesn't even have to provide the reason to the school. They can just say, I disagree with your evaluation and I want one funded by you. And they get to go then pick out their own evaluator, who's an independent evaluator. This should be done in writing, and in general, we say include a short description as to why you disagree. You don't have to go into details, but if you say, my child first started learning Spanish and you did this entire evaluation in English, and you need to do one in Spanish. Just something essentially because the LEA either has the choice to authorize it immediately, or they can actually take action against the parent to defend their evaluation. I've never seen this happen. I know some school districts do it, but in general, what we see a lot is that the school district might not authorize it, and then we actually file a due process complaint to get the funding to do it. So when we say maybe like a brief description, just so that if you do end up having a due process complaint filed against you because the school district doesn't want to pay for it, you can say, you know, I did provide the notice saying like, you know, it was only an hour long and they didn't seem interested in the child, or they barely even talked to me about my concerns. And as I said, if you have requested an IE, they haven't acted on it, and they also haven't filed a due process complaint against you, then you can actually file the due process complaint yourself. So let's hope that all went well with the evaluations. Everybody agrees that the child was eligible. At that point, they're going to actually develop the IEP. So this is going to be, remember, that written document that's kind of like a contract that lists all the services that the child's gonna require, how they're currently functioning, what accommodations they might need to their curriculum. It's gonna be developed by the MDT or IEP team, and it must include each of these things. IEPs look entirely different depending on the county, really. They can create the document however they want, it just has to contain these things within it. So some related services that you might see. Common ones at the top: speech, occupational therapy, physical therapy, counseling, or behavioral support services. But the child might actually need medical services. The case law from the Supreme Court actually has required that, for example, if a child needs catheterization from a nurse to be able to attend school, the school has to provide that. Same for students that might have a G-tube and are fed through the tube in their stomach. If that is necessary for the child to be able to attend school during the day, they have to provide a nurse or other qualified person who would be able to administer that. And one thing to point out here, parent counseling and training, this actually could be a service on the IEP that's provided to the parent or the caregiver to help the child. You'll see this probably most often students that might be blind and the parent is taught how to learn Braille so that they could read to them or help the child learn to read there. Same thing with sign language for students who are deaf or hearing impaired. IEP teams are like a complicated animal. I mean, it depends, you know, there isn't any specific guidance as to what if 3 people are for it and 3 are against it, what happens, or what if 5 people are for it and 1 is against it. There isn't, you know, like a breakdown as to how things are supposed to be sorted out that way. But you'll definitely see sometimes teachers will become the advocate for the student and then be advocating against the psychologist or vice versa. So some accommodations or modifications that would also be listed on the IEP that you might see. Some students might require a dedicated aide, and that's actually listed, it's within accommodations and modifications, but sometimes it's listed under a whole different category on the IEP. Again, it depends on the school district that you're working with. Some other things, maybe a child needs a certain type of chair in order to be able to participate. I actually worked with a little boy who had pretty severe cerebral palsy, and the school that he was first in, he would sit in his wheelchair the entire day and wasn't able to actually participate in story time with his peers, for example, when he was in kindergarten and get on the floor. We were able to get some adaptive equipment so that he had what's called a corner chair, and he could it would first of all work on his posture and his strengthening his neck muscles, but also allow him to participate on the floor with his peers. Some other things that are pretty basic, and usually school districts are pretty good about accommodating: breaks during tests, testing at the best time of day, you know, repeated directions, the use of a calculator. Those things can all be accommodations for students. They're listed as addendums because, again, frequently they're not part of the actual IEP document, but maybe the pages behind it. These different services can also be included. Transportation, extended school year, that generally looks like services outside of the normal school year. A lot of schools will just say it's 6 weeks over the summer. It technically needs to be looked at on the child's individual needs. So in theory, if a child needs continuing instruction over winter break, then that's what the school district should be doing. You'll see a lot of times that it is just kind of created like, this is our extended school year program, she can come for 3 weeks over the summer or whatever it might be, but it should be individually created. A behavior intervention plan. This is going to be important for students that have any type of behavioral difficulties at school that are interfering with their academic progress. The functional behavior assessment is really a key evaluation. to be done before the BIP is developed, and that really looks at what the child, what's the function of the behavior. And then lastly, the transition plan for students once they're age 16, what's gonna happen afterwards. So after developing the IEP, the team is then gonna figure out what the placement is, and that can be a pretty complicated and controversial topic. They're supposed to be selected from the Continuum of Placements that are available on the IDEIA, and it's supposed to be based again on the individual needs of the child, but it can be pretty confusing, as I said. Sometimes it could actually mean what school the child is going to, but it could also just mean what the services they are receiving and where they're receiving them within their neighborhood school. So in a resource room or a special education classroom, or within a self-contained classroom at an entirely different school. Parents are absolutely required to be part of the decision makers here, and it has to be reviewed annually. This is the continuum of placements, and it includes kind of everything you can imagine: regular classes, special schools, home instruction, and instruction in hospitals and institutions. As I stated earlier, it has to be reviewed and revised as necessary, but at the very least once per year. So at least once a year, there should be an IEP meeting. If you have concerns prior to that, a parent can request it at any time. Every 3 years, the child should be reevaluated, and school districts sometimes vary on what they determine as a reevaluation. Some school districts might try to push back and say, you don't need formal new evaluations, we can just look at the data that we have from report cards or standardized testing. But a parent that wants reevaluations can request that, and the school district should provide it unless the parent has basically consented in writing to just have a data review. Some procedural safeguards are the requirements that they have to follow to provide notice to parents, for example. These are all the things that they have to provide. A big one is the prior written notice. Anytime a school district is proposing to change the student's IEP or placement, or refusing to take action, like to do a reevaluation, they have to provide written notice about what they're doing and why. There are disciplinary protections for students with disabilities. The big one is that students cannot be suspended or excluded from class for more than 10 days in a whole school year. So not 10 days in one suspension, but adding them all up, 10 days, because it's constitute a change in placement if they do. So prior to any suspension, after that 10-day mark, there has to be a manifestation meeting to determine if the behavior is a manifestation of the child's disability. And that's the meeting that you have where you basically consider whether or not the disciplinary action was substantially related to the child's disability, and if it is, then the suspension cannot happen. This is kind of more information about the same that we can go over in more detail. I just want to make sure I get to section 504. As I said, if a parent disagrees with any of the school's actions during the evaluation process, during the IEP process, anytime, the parents can take legal action against the school district. They can request a due process hearing, which is kind of an administrative hearing, but they may be able to resolve it prior to actually requesting a hearing through mediation or just requesting another IEP meeting. All right, we're gonna go through section 504 really quickly. So section 504 of the Rehabilitation Act of 1973 is a really broad civil rights law, and it protects individuals with disabilities from discrimination from any agency, school, or institution receiving federal funds. So it actually applies across the country really broadly, but for students, it establishes basically the opportunity to participate fully with their peers. And so there are affirmative obligations for school districts to follow. To be protected under section 504, you must be determined to have a physical or mental impairment that substantially limits one or more major life activities. They can't consider mitigating measures. So for example, medication should not be considered when you're determining if the child has a disability. Same thing with, for example, hearing aids. Yes, maybe the child is going to wear hearing aids at school, but you can't say, oh, she doesn't have a hearing impairment because with her hearing aids, she's okay. And these are some major life activities. Learning is one of them. So if whatever the disability is impacting the child's ability to learn, then that would qualify under section 504. What do schools have to do? So they have to provide a FAPE, just like they did under the IDEA. They have to provide that free appropriate public education. The definition is a little bit different here though. They have to provide regular or special education and related aids and services designed to meet individual needs of the students with disabilities as adequately as students without disabilities are met. So kind of what they have to do here is eliminate barriers that would effectively discriminate against the student. So if a child wants to participate in aftercare and needs a dedicated aide to do so, technically the school district is required to provide that dedicated aide in aftercare if it's providing aftercare to children without disabilities as well. For evaluations, they also have to evaluate. So it's kind of a similar concept to child find. They have to figure out what childs might need 504 evaluations. Parents do have to consent, and then they have to reevaluate, but it's not every 3 years. It's only after a significant change of placement. That might be the suspensions again that we talked about, or it might be, you know, this child is going to be going from elementary school to middle school and it's going to be a whole different world there. So that might be a time when they are going to need a new evaluation. But at other times, it's just periodically. The content of the 504 plan is going to look a lot different from an IEP. First of all, in general, because the student is not going to have an adverse educational impact if they're getting a 504 plan, it's more or less going to be implemented through regular education teachers, maybe a nurse or a social worker, the occupational therapist that's providing occupational therapy, but it's not likely going to have a special education teacher providing specific academic instruction. It should include any accommodations and services that are necessary. So for, again, example, a nurse, any behavior interventions, accommodations, giving the child time to walk around the classroom when they need breaks. It could be transportation. It technically could be specialized instruction, but as I said, since it's not going to be to reduce or to remediate academic deficits, that's not something you'd see too often. So there's actually no set team of people like with the IEP. It's actually not required that parents participate. So technically, schools could hold a 504 meeting without a parent being there. It doesn't happen. I haven't seen it happen anyways, I should say, but it could happen in theory because it's not required. So school districts must also provide the same procedural rights to parents that they do for under the IDEIA. And they must have a dispute resolution or hearing mechanism for parents as well when there's disagreement. And the disciplinary protections we discussed are also eligible for students who have a 504 plan. As I said, they're not going to be used generally for kids that have a learning disability or something that's impacting their academic progress. These are some examples of when you might see them needed, and many children with narcolepsy might qualify for a 504 plan and not need the special education services. It depends on the child's needs. If it's impacting their academic progress, then they should get the special education services, but it could just be, accommodations for the child during the school day. So, generally, which plan do you choose? Well, you have to qualify for special education, but if there was some type of concern, parents and children generally have greater protections under the special education services, under the IDEA, and also it's easier to get services in place, so things like speech or occupational therapy. And the reasoning for that could be that schools can draw down federal funds from the IDEA, but schools actually have to pay for 504 services themselves. Okay, so this is just a screen that kind of goes through the differences between special education and 504. I'm happy to talk with you guys more. I've kind of gone through these, but I did just want to really quickly touch on post-secondary education because I know there were some questions. So under the IDEA, students again receive services through age 21, or some school districts through the semester they turn 22. So if you've graduated school though at age 18 with a diploma, you're not going to be entitled to special education services anymore. So in college, no special education services. Luckily, Section 504 does provide protections though, and so students that need ongoing accommodations and that are going to educational institutions that are receiving federal funds do get protections of 504. And these are some of the protections. They can't be denied admission, the school must make reasonable accommodations, they can't be excluded or denied benefits from any type of academic or, let's say, research opportunities just because they have a disability. They have access to housing, health insurance, counseling, all equal access as students without disabilities. So some modifications that might be required, again, they're pretty basic, but changes in the length of time to complete degree requirements or for specific courses, allowing certain auxiliary aids if a student needs to have a tape recorder to record the lecture. And for example, students that have narcolepsy might be entitled to have a quiet study carrel or private space for naps during the school day. Here, in this last slide, I have the link for the Parent Center Network, which lists the Parent Training and Information Center for every state. Each state under the IDEIA has a Parent Trainer Information Center that provides information about, well, just general education information, but also resources to advocates or attorneys if you feel that you need assistance.